Hey guys, in this video, we're going to talk about what it means when USCIS says to you, they're going to hold on to your I-130 petition and they're not going to do anything further with it. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law. Friends, before you go today, be sure to subscribe to my channel and hit that notification bell so that you'll be the first to get notice of my videos each week. Now, the notice that I'm referring to is the I-79C notice of action that is sent to individuals once the I-130 family petition has been approved. That approval notice will say something like, the petition has been approved, but the petition didn't indicate where the beneficiary intends to apply for an immigrant visa abroad or in the U.S. Therefore, USCIS has retained the petition. The I-130 family petition is the critical petition that carries the entire green card process for an individual who's here in the United States or abroad. It's the relative petition. And once that I-130 is approved, USCIS will look to the petition for further direction about what it should do with your petition now that they've approved it. If you told USCIS that your relative is right here in the United States, they're in Detroit, Michigan, or Brooklyn, New York, or Cincinnati, Ohio, and they plan to apply for adjustment of status, well, USCIS, with this knowledge, will hold on to the petition and allow your relative's case to continue processing at a local field office through the adjustment of status approval adjudication process. However, if you told USCIS that your relative is abroad, they're in Italy or Hong Kong, then USCIS will know that they should send that approved I-130 petition to the National Visa Center for further processing. Once it goes over to the Visa Center, the petitioner will receive an email from the National Visa Center telling them that we have your petition. Here are the additional steps that you'll now need to take to further your case. Just to clarify, there are very specific steps that are required during this process. Firstly, an I-130 petition is filed. On that petition, you will notice that questions from 61A through 62C specifically hones in on the issue of what should USCIS do next? Where is the applicant or the immigrant? So here under step 1 on the I-130 on page 8, question 61A and 61B has to do with the issue of adjustment of status. And here's what it says. The beneficiary is in the United States and will apply for adjustment of status to that of a lawful permanent resident at the U.S. Citizenship and Immigration Services office in, and then you've got to indicate which city and state that this beneficiary is located in. If your relative is here in the U.S. and they will do adjustment of status, this is where you will be instructing USCIS to hold on to your petition for further processing at that local field office. However, now, if your relative is abroad, then you jump to questions 62A through 62C, which the beneficiary will not apply for adjustment of status in the United States, but he or she will apply for an immigrant visa abroad at the U.S. Embassy or U.S. Consulate in the city, the province, and the country. If you took the steps to complete these questions, USCIS will follow your instructions and they will either send your case to the NVC for further processing or they'll hold on to it, waiting for adjustment of status at the USCIS field office. So that's step 1, completing these questions carefully. Now, after USCIS has approved your petition, this is where step 2 will come into play. Step 2 will be to look at the new approval notice from USCIS, and that approval notice will tell you, okay, we've seen that you've indicated that your relative will do adjustment of status at such and such field office, and we know that. Great. So the process will continue. Or your approval notice will say, we will be sending your case to the National Visa Center for further processing. So those are the 2 steps, guys, related to the I-130 if done correctly. When you receive the letter stating that we're going to hold on to it because we don't know what to do with it, it means you had some blank spaces on your I-130. You did not complete questions 61A through 62C. So USCIS, their hands are tied and they don't know what to do with your case. This problem can be resolved, friends. You could work with an attorney to help you resolve it, or you could try to resolve it on your own, but you've got to inform USCIS what your plans are, whether your relative plans to do adjustment of status. If that's the case, then the relative should file for adjustment of status, and it'll all be taken care of that way. However, if your relative is truly abroad and will be going through an immigrant visa process, you have to take the additional next step to file the form I-824 with USCIS to ask them to send this approved I-130 case over to the National Visa Center. If you don't file that form with them, guys, they will sit on your case. You won't have any further actions on that I-130. So very critical. If your relative is abroad again, go ahead, file the I-824 form with USCIS, pay that filing fee, wait several months for them to approve it, and after they've approved it, you will be notified of that. You'll get an approval notice, and then the National Visa Center will contact you shortly thereafter. Friends, I hope you found this informative. Be sure to share it with other people. If you'd like more free tips from us, subscribe to the #1 immigration newsletter at McBeanLaw.com/subscribe. Thanks so much for being with me in this one, and I will see you in the next one. Bye-bye.